Okay, welcome. Welcome to our live stream. I'm Tate Lounsbury with my court coach, and this is California family law attorney extraordinaire, Chris Fontal.
Hi, Tate.
Hi, how are you?
Good. How are you?
I'm doing fine, thanks. So, welcome to our live stream. If you're not aware, my court coach is an online resource for everything related to family court and representing yourself in court. There are all sorts of resources and helps there, guides, checklists, scripts, templates, anything that you can need to represent yourself in family court. Today, we're doing a Q&A with Mr. Fontal here, where we're going to discuss some questions that have been asked by our viewers. People who have commented on videos on our YouTube channel. So, are we ready to get started, Chris?
Sure.
All right. As we do, I want you to remember that what you're hearing today is not legal advice. We're not giving you advice on what you should be doing in your particular case. We're just commenting on the generalities and family court and filling out these the family law forms from the Judicial Council. So don't take anything we have as advice specifically for you. And if you do decide to ask a question or share information, we recommend that you not provide your name or share any details about kids in your case that are involved in your case, because this obviously is a public forum. All right, so let's get started. First question we'll discuss is a comment on our video, when to use the family-centered case resolution order in California Family Court related to court form FL 174. And this person says, thank you. This video is very helpful. I'm in divorce process. Financial discovery is difficult to complete. He hides money from me. So this is the wife or mom. Subpoena served to his company, but his company didn't produce documents. I wanted the FL 174 may needed. Maybe she means maybe needed. And her question is, I think, what do I do if I send a subpoena to my ex's employer requesting documents and they don't produce the documents? I think that's the question. Is that how you read it?
Yeah, it's a little unclear because I can't see how this form would help her in any way regarding obtaining documents from anybody by subpoena.
Yeah.
What you do, if it's been properly served and they absolutely just don't want to even acknowledge receipt, you're going to have to haul them into court somehow. And it's either a motion for contempt or some kind of something else. And so I'm not exactly sure what she sent over to this employer. So I'm not exactly sure which way you would go about enforcing it. I mean, one way to get documents from an employer would be a deposition subpoena for documents, and failure to participate in that deposition certainly could lead to monetary sanctions. But I'd have to look at whatever papers were submitted and whether or not any objections were made and all the details, because it really gets down to the details for something like this.
Yeah. What I would recommend is I'll show her. Let me show another screen here. So if you go to our channel, the My Court Coach YouTube channel, you can hit playlists and go to the different created playlists, and there's going to be a playlist regarding discovery. You see this one right here, says Discovery in California Family Court. And you can learn all about subpoenas and how to use them and how to, and then if you go to this playlist here, it talks about enforcement of California Family Court orders. Those are some that's 14 videos on discovery and 25 videos on enforcement. Chances are you're going to find information in one of those two playlists that will help you resolve the situation that you're going through. So hopefully that works and that's helpful. Any more? I'm not sure why maybe she just happened to be on the video for the FL 174 and that's when she thought of the question.
Maybe. I don't know.
Yeah. Okay. All right. Do you want to say anything more about that, or should we go to the next one?
Next.
Here's a question regarding our video, or comment on our video: how, why, and when to request a joinder in California Family Court. This is a comment on our video regarding Family Court Form FL 371, Notice of Motion and Declaration for Joinder. And the commenter asks, once I have been joined, what form do I use to respond? It is for a family law case. Do I respond to the original RFO? RFO stands for Request for Order. Maybe you can just do a brief explanation of what a joinder is and then see how you answer that question.
Well, there's different kinds of joinders. The most common one that we see would be the joinder of some kind of a pension plan that one of the parties has. And generally speaking, it's not something that ever gets contested in any way. Like if, I don't know, mom works for the fire department, dad might do a joinder to join the fire department's pension program. And the whole point of that joinder is so that the court can make orders dividing the pension. And otherwise, technically, they're not a party, and so technically they don't have to follow the orders. It's probably the best way to describe it for that kind of joinder. There are other joinders. You can actually try and join just about anybody into a family law case for any reason whatsoever. Those tend to be a lot more litigated. For example, if you had one of the parties or both of the parties owned a business during the marriage, or let's say they owned like 10% of a business in the marriage, somebody might want to join the business in order to be able to do discovery on that business and to see who really owns what, when, where, and how, and whether or not they really own 10%. The problem with that is the person or persons who own the 90% of that business, they might not like that too much. And they might say, wait a minute, we're having some kind of a dispute on who owns the business. If so, we want a jury trial. And you can't have a jury trial in a family law case. So it just depends on what kind of joinder we're talking about. Now, in that particular video that we're looking at, looks like an FL 371. And so that's basically just joinders regarding pension plans, I think. Let me look at that one. No, this is the general joinder for joining anyone for any reason.
Like grandparents?
It could be. I'm not sure.
Like if a grandparent wants to get involved and wants some custody rights, or let's say the two parents are minors, or if not minors, high schoolers, and so both sides of the grandparents say, hey, these are still kids. Let's get involved. Or just one side of it, one grandparent.
I don't think this is the right form. Possibly. I mean, the problem is these form numbers, FL 370 is dealing with an employee benefit plan. 371 is a notice in motion for the joinder. So like when you want to join a benefit plan, you do an FL 370, 371, and then you would do a 372 as well. Although maybe you wouldn't have to do a 371 if you did a 372.
So say there's a dad files a request for, let's say it's young parents, and mom lives with her parents with a newborn baby, and dad's parents are saying, which are the child's grandparents now, are saying, hey, we need to get involved. Let's get joined into this case because dad's in high school, or he works at Baskin Robbins, and it's really going to be the grandparents taking care of the child. And so if the grandparent says, hey, I need to get joined, the paternal grandparents need to get joined. And so this question, I think, is saying, I've already been joined. Now, how do I respond to this request for order? How do I get involved in this? There's probably a request for an order regarding child custody or something like that. And they want to be involved so that they can get an order allowing them to share in custody. Would they just respond to the RFO after they're joined?
Well, usually you would respond to the RFO for the joinder before you're joined so that you could, assuming they want to object. But let's say this is a grandparent that wants to be joined, and so they didn't oppose the joinder, but now they're in the case. If the grandparent then wanted to somehow address the issue of custody and visitation of the minor child, they would simply file a request for order to deal with the issue of custody and visitation of the minor child.
So it's not good enough to respond to the original RFO. You think they'd have to file their own RFO so that they can get an order related to them for custody for them.
Right. Because whenever you deal with the issue of custody and visitation, it requires a separate request for order, RFO. And whenever that happens, the court is then supposed to refer people to talk to court-connected social workers. Like in San Diego, they call it family court services. And so that way the social worker can be involved with having a meeting between the parents and whoever else is joined regarding that issue. To talk about the issue of custody and visitation.
Yeah, I wonder if it'll matter in what's put in the original RFO. So let's say mom requests an order, and in her request, she's saying, "Hey, judge, will you please give dad's parents, weekends with the baby?" If she is already putting into her own RFO sort of an assumption that the joinder is going to happen, then there's probably not a notice problem, which maybe they wouldn't have to file the grandparents would not have to file their own RFO. They could just respond. Maybe, I'm not sure. Normally the problem with just responding, not filing your own RFO is if the issue hasn't been brought up in the original, then you need to file your own, right?
Well, you forgot one little thing. The court wants to collect its fees, and that includes the fee to go back to family court services. So, it's something that happens that, when you try and do it with the computer, they have to have that RFO form in front of them so that they can schedule things as well as charge the appropriate fees. And that would be true even if somebody had a fee waiver, because then they would charge the fee to whatever fund is paying for that fee waiver. And so, yeah, I mean, the thing is, when it comes to grandparent visitation, we just don't see it that often. And so there may not be a whole lot of uniformity with the various departments on how they handle it. So even though they may supposed to be handling it one way, they may do something else. And so generally, once you get joined into the case, the judge is going to give people some kind of an indication of what they expect them to do next. And usually they'll, if the grandparents will say, oh, I want to get involved in custody visitation, the judge will say, okay, I need you to file a request for order. And then they'll schedule the dates, and then we'll come back and take a look at it.
Yeah, and filing your own is the safest way to go. That way you know that you can be heard, rather than just assuming you can respond to the original RFO.
Yeah, I'd have to, like you said, I'd have to read that original RFO to figure out what's in it and who responds to it and when. It's going to depend on who it's directed at. Because sometimes, usually you do these things where you direct it at the opposing party to see if they're going to object to it first. And again, it depends on what it is you're trying to join and for what purpose.
You'd hate to assume you can just respond to an RFO, go ahead and respond, and then you show up to court 2 months later and the judge says, hey, no, that's not good enough. You got to file your own. You just wasted several months.
Well, except that you can't file your own RFO if you haven't been joined into the case.
Yeah, I think this question is assuming that joinder's already happened.
Right. Okay.
That's the way it seems anyway. Or file a joinder. Can you file an RFO at the same time as a joinder? I don't know that you can do that. My guess is no. Do you happen to know?
I'm sorry, I missed that. What was it?
Whether they could file a motion for joinder and an RFO, assuming the joinder is granted. Can they file at the same time?
Maybe.
Yeah, I don't know.
And then, it might be depending on how the judge wants to deal with it at that point. I mean, you do have kind of notice problems, but it is the family court, so they have a tendency to figure that stuff out, especially if everybody is consenting to be involved. You get into some crazy stuff if somebody actually wants to object to the joinder. Like if I've got a 10% ownership in a business and the 90% owner doesn't want to be in family court, then that's a different story.
Mm-hmm. All right, let's look at the next. Are we ready for the next one?
Yep.
Okay. This question is on our video about how to keep control over how and when you pay spousal support. This is form FL 450. Request for hearing regarding earnings assignment. And the question, before we go over the question, you might, before you answer the question, you might go over what an earnings assignment is, just briefly. The question is, when do you send this FL 450? Do you include it in the packet that goes to the employer, or do you send it afterwards?
I've never sent one of those out. And I'm looking at the form, and it looks like it's a governmental form. So maybe Department of Child Support Services sends that out when they send out the wage assignment order. But in any event, if an employer receives this, let's say they receive a wage assignment for somebody named David Smith, and they have an employee named David Smith. Then they give this thing to David Smith that says, hey, you've got to pay whatever, $2,000 a month for this child. And David Smith is going, I don't have a child. What's going on here? And it turns out they've got the wrong David Smith. And so this form would be useful for the wrong David Smith to say, hey, you got the wrong David Smith. Leave my paycheck alone. So whenever you send out the wage garnishment order, or whenever the Department of Child Support Services sends out the wage garnishment order, they would send this form out so that the support payor would have an opportunity to challenge whether or not he was actually ordered to pay the support. And in fact, if you look at the box, the first check box is number 2. It says, I am not the obligor named in the earnings assignment. And so that would be the most relevant case, I guess, the most often case. Now if you are the correct David Smith and you in fact have a wage garnishment against you and it is your child and you were in court at the time the order was made, you're not going to be able to use this thing to set up any kind of a meaningful challenge to the support order using this kind of a form. And in fact, you're not going to be able to challenge it at all, except possibly through an appeals process, because usually this is after you've already had a hearing. Did that make any sense, or did I?
Yeah, because it says complete and file this form with the court clerk to request a hearing only if you object to the income withholding for support or earnings assignment order. This form may not be used to modify current child support amount.
And you'd be surprised how many David Smiths there are out there, or John Smith, or.
Yeah. All right. All right. Anything more to say about that one?
Nope.
Okay. Let's go to the next. All right. This question, this comment is on our video about the judgment form. And the commenter says, why is custody not separate from a petition for paternity case? I have legal insurance that covers 100% of custody case, but only $2,400 of petition for paternity case. And I'm already up to $8,000 with my lawyer, SMFH. So I guess this is more of a complaint of his legal insurance plan that he has.
Right. Well, I mean, I guess that's just the way the insurance plan works. Why are they together? Because it makes sense to the court to have them together. If the issue of paternity has not been already established, then it would make sense to establish that paternity and at the same time decide what custody and visitation is going to be for the case. There is a possibility that it was not filed properly. I mean, I don't know why. I don't know if he's contesting whether or not he is the father in the case. But there's a lot of times.
Mm-hmm.
You do see a lot of times when people file a petition for paternity when in fact the father has already established paternity by way of the voluntary declaration of paternity form. And as such, the correct type of case would be a petition for custody and visitation and support, because the issue of paternity is not something that would need to have a trial. And it might be interesting for this individual to file a motion to change the type of case from a paternity case to just a custody and visitation case, if that's possible. I've never heard of any legal insurance that covers 100% of anything in family court. So I think it's kind of an interesting issue.
Yeah.
Because it could be quite expensive. I mean, you could have, two Hollywood actors and actresses arguing about something, and the cost of the attorney's fees could be in the millions. So I don't know. I mean, that's interesting.
Yeah, he must be disputing paternity. Otherwise, why would he rack up $8,000 in fees? I mean, that would be an easy thing if he's agreeing.
Oh no, I see people racking up those kinds of attorney's fees when paternity was established 10 years ago.
On the paternity issue, just racking up $8,000 in fees just on that sole issue of paternity, when it's already
I'm talking about $8,000 just on the issue of arguing about custody and visitation.
Yeah, this guy seems.
I don't know.
Yeah, yeah. For custody and visitation, certainly, yeah. But for paternity, he must be, like you said, it must be going to trial or something, and he's disputing paternity.
And it also depends a lot on who his attorney is.
Right.
Some attorneys charge a lot more and are a lot more thorough.
Mm-hmm. Mm-hmm. Okay. Sorry you're going through that. That's just the way it is. Maybe look for a different plan, I guess. All right, let's go to the next one. Okay, this is a question about move-aways. We have a video about child move-away and child custody in California Family Court and what you need to know about it. And the commenter says, do I need to let the court know that we are moving away if I already have full custody of the child or children? If so, what forms do I need to submit? So this person presumably lives in California, has full custody of a child, and is going to be moving. It doesn't say whether it's out of state or out of county and still within the state of California, but they're moving away and says, can I just take off? Or do I need to let the court know? And do I need to get permission? and what forms do I file if I do need to let the court know and get permission?
Right. I mean, the first thing I would do is read whatever custody orders that she has. That's going to tell us which direction to go on a case like this. And it's going to depend a lot on what's in that written order and a lot on whether she's got 51% custody or whether she's got 80% custody. Once you look at that, you can start figuring out which presumptions apply. But most of the court orders that I see make it very clear that if you have custody and you want to move with the child out of the area, that you need to either have a written agreement with the other parent, or if that's not possible, which it usually isn't, then the person who's moving needs to file the motion to move away, so that the court can make appropriate exit orders. And if mom has 80% custody and dad has 20% visitation, she absolutely has a right to move, assuming that their final orders have already been made in the case. And I don't know. I mean, she says she has full custody, but it doesn't say whether it is a Montenegro v. Diaz final order or whether these are temporary orders pending final trial. But assuming she's got final orders under Montenegro v. Diaz, or a judgment or something like that, then she has an absolute presumptive right to be able to move. The question then becomes, what is the court going to order for dad as far as visitation going forward? And, I mean, he's not, assuming they're both living in San Diego County, somewhat close to each other. Obviously, if she moves to Florida or Texas or something like that, they're not going to continue to have weekend or every other weekend visitation or whatever's in the current order. So the court's going to have to do something. And that something would be figured out by filing a request for order saying, checking the boxes for custody, visitation, and move away.
Mm-hmm.
And
yeah, that's
my
going to be
my suggestion is to file it early, because it may take a while to resolve.
Yeah, probably will, unless the dad is just completely not in the picture, maybe, or something like that.
Right. I mean, right now would be a good time to file if you're planning on moving out of state in June or July. In fact, it may be a little on the late side if the other side wants to challenge it.
Yeah, eight months ahead of time.
Yeah, because the father would have a presumptive right to have a trial on some of these issues if he can show that there's a detriment. Then he would have the right to have a trial, and the family court is not. What's the word? They don't have a whole lot of time slots available for trials anytime. And so trying to get a one-day trial out of the family court today might take 9 months to a year, depending on what department you're in.
What department, what county. You mentioned Montenegro order. We do have a video, maybe videos that talk about what a Montenegro order is. Again, we highly recommend you go to our YouTube channel, my Court Coach YouTube channel. Go to the playlists, and you'll see one of the playlists is child custody in California family court. Now, I know that it says there are 17 videos. That may be a lot. Watch them. We have a discussion. We have a video where they discuss Montenegro orders, and that's going to be very important in your situation, whether this is whether the status of your case is after judgment, after a final order, or you only have temporary orders, as Chris mentioned. Anything else about that topic?
That should do it.
Okay. All right. We only have one more about Family Law Form FL 343. Should we get to that one a different day?
Yeah.
Yeah. So okay. Yep, it's been a half an hour. Thank you so much for joining us. I hope this is helpful. I hope it's we pointed you in the right direction of ideas that you can take in your case. And Chris, I want to thank you so much for your help today.
You're welcome.
All right, check out mycourtcoach.com. Please, if you think this is helpful, give us a like. Go ahead and like the video. It will help other people find it. And please subscribe. That way you can be notified next time we do a live stream. And again, it helps more people get more help. We all know that family court is tough and it's stressful. Family lawyers are expensive, as this one gentleman who made that comment, how he knows now. Family lawyers are expensive. It doesn't have to be. You can do it yourself with some help. And My Court Coach aims to provide that help. All right, we're signing off. Thanks, Chris. Have a good night.
Thanks, bud.
All right, till next time.